Then you file it with the copy meeting.
Actually, my lord, altogether, two charges were. My
Basic ground.
Basic
You
ground.
must have gone in appeal.
Yes. Appeal dismissed.
Revision.
Yes.
Revision. So now after 3
No revision I have not gone, my lord. Only
Revision.
appeal. Only appeal.
So
Because this was not a case of major punishment, therefore revision was not entertainable.
not maintainable.
Yes, ma'am.
All right. So after two courts,
Yes,
two
ma'am.
authorities,
Yes, ma'am.
what is the ground you are raising in the matter of a department?
Yes. First two is that the copy of inquiry report was not served to the petitioner. Second is no opportunity of cross-examination. As per appendix 1 of Jharkhand Police Manual, that was not provided to the petitioner. And third is the charge upon which he was, my lord, inflicted with this punishment, that he was negligent in investigating a case. This was the charge.
Any charge of corruption?
No, nothing like that. Only negligence in investigating a case. That was the charge.
What was the case about?
Case was, an FIR was lodged while he was IU of that case, my lord. So the trial court ordered a specific order that the investigation is not proper. Therefore, he was departmentally proceeded in this case, my lord.
The trial court's order is on record?
Yes. Apart from this thing,
Just a minute. What was the case? FIR under this section?
yes, ma'am. That FIR is that is annexed in the annexure C of the counter affidavit, annexure A of the counter affidavit. That was under
Where is the order of acquittal?
annexure A of the counter affidavit.
Why in the annexure A it will come?
Because this order was not served to me, it was on in different case, my lord. Therefore, the respondents have filed this annexure. Annexure A, page 35. This is the order upon which second page, page 36 is relevant bottom part. Hence, to meet the end of justice, I do feel to appreciate.
No, you did it.
Yes, ma'am.
28/3/2011.
A petition along with order sheet of date dated 24/3/11 of GR case number so and so and filed was placed today. In course of hearing, it was brought to the knowledge of the court that the learned lawyer for the prosecution that inadvertently due to lack of knowledge of law, the IO of the case has submitted final form in the case, convincing from the fact that he has already filed a petition for further investigation in Manika PS case number so and so. In this case, the prayer of RO regarding further investigation of this was rejected, influencing from the reality. Since this is a case in which huge amount of public money appears to be misappropriated, until today the case has Manrega, no, madam.
Manika PS is all Manrega. 420?
420, 467 and all. So it was observed in this order, my lord, there has been latches in investigation, and therefore since
Therefore they have not dismissed you. They have put it at the lowest.
Yes, that is. So I don't have much better case. My lord, I passed orders.
Annexure 1 is a charge sheet.
Yes.
Give me the foundational dates.
Yes, ma'am. 5/7/1976 he was appointed as constable, madam.
5/7
1976.
constable.
Thereafter, the charge was served. Charge sheet is annexure 1. It was served on 21/4/2011.
Your response?
My response is annexure. My response is not here. Annexure 3 is the month of inquiry report, my lord.
Where is it?
Annexure 3, page 23. Annexure 2, page 23.
Annexure.
Two.
Annexure 2 is what?
Month of inquiry report.
Inquiry. What is the date?
This is dated 9/6/2012.
9/6/2012. You participated?
Yes, I participated. Only cross-examination opportunity was not provided.
Anything denied?
No. Thereafter, annexure
How many witnesses were examined?
altogether 3 witnesses were examined. No?
From the side of the department?
Yes. Puani Anil Singh, Asu Puani Harendra Paswan. However, only verified the signature and evidences, my lord. They only verified those things, technical aspects. Thereafter, by annexure 3, another report is there, that is of SP.
Just बचाव आरोपित समीम अहमद द्वारा अब तक इस विभागीय कार्रवाई में संचालन के द्वारा कोई स्पष्टीकरण समर्पित नहीं किया। You do not respond to the charge.
No, it is not there, so I will.
It is there, barrel number.
No, it is not in my annexure, therefore I cannot admit it.
So-
Perhaps he has not submitted his reply.
This- जरा पढ़िए पेज नंबर 24 का पैरा नंबर 4.
Yes, ma'am. साक्षी
पैरा नंबर 4 थोड़ा नीचे बीच में है। आरोपित
आरोपी पर लगाए गए आरोप संचिका में उपलब्ध प्रदर्श साक्षी।
पेज नंबर 24
यस मैम।
वो पैरा नंबर 4 शुरू हो रहा है ना, बचाव लेफ्ट हैंड साइड में बचाव इंक्वायरी रिपोर्ट का है, सेकंड लास्ट पेज।
सेकंड लास्ट पेज मंतव्य के ऊपर बचाव
बचाव
आरोपित सहनी समीम अहमद द्वारा अब तक उस विभागीय कार्रवाई में संचालन में दौरान कोई स्पष्टीकरण समर्पित नहीं किया गया है। यह विभागीय कार्रवाई दिनांक 20/4/11 से लंबित चल रहा था तथा संचालन के दौरान आरोपित को प्रत्येक माह में दिनांक 5 एवं 25 तारीख को तिथि निर्धारित कर मेरे कार्यालय से वितरित संवाद संख्या इतना 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 से आरोपित के द्वारा स्पष्टीकरण समर्पित करने हेतु सूचित किया गया है, परंतु अब तक आरोपित मात्र एक बार उपस्थित हुए एवं अपने नीति अपनाते हुए चले गए, टाल मटोल की नीति अपनाते हुए चले गए। मेरे द्वारा आरोपित को बचाव स्पष्टीकरण समर्पित करने हेतु भेजे गए नोटिस के आलोक में रक्षित कार्यालय लातेहार के पत्रांक सो के माध्यम से पुलिस अधीक्षक महोदय लातेहार द्वारा भी आरोपित को सूचना दी गई है, परंतु बार बार सूचना भेजे जाने के बावजूद आरोपित अपना बचाव स्पष्टीकरण समर्पित नहीं किए हैं। पुनः इस कार्यालय के फैक्स संख्या इतना सो के माध्यम से संचालन की तिथि निर्धारित कर नोटिस का तामीला आरोपित को कराया गया है, परंतु आरोपित न तो संचालन में उपस्थित हुए हैं न ही अपना बचाव स्पष्टीकरण समर्पित किए, जिससे प्रतीत होता है कि आरोपित को अपने बचाव में कुछ नहीं। यस, बट वन annexure I would like to show, my lord, that is irony to this same because
as per the inquiry
Yes,
report
yes.
he appeared once.
yes
आगे
जी आरोपित पर लगाए गए आरोप संचिका में उपलब्ध प्रदर्श साक्षियों के बयान से ज्ञात होता है कि आरोपित सहनी समीम अहमद की पदस्थापन मनिका थाना में सहनी के रूप में थी। तो दिनांक 3/3/2009 को मारपीट की घटना घटी थी, जिसमें वादी नियामत अंसारी के लिखित बयान के आधार पर मनिका थाना कांड संख्या सो दिनांक धारा 341 42 23 504 34 बाद अभी अंकित किया गया था। बाद में परिवर्तित धारा ज्ञात एवं पुलिस झारखंड।
उसके बाद क्या हुआ?
इसके बाद आई वॉज हेल्ड गिल्टी ऑफ द एलियस चार्जेस मैडम। one annexure that helps me, my lord, in this case, that is disciplinary authority order. What is his observations? That is this is annexure page 37, my lord.
What is annexure 3?
Annexure 3 is the another inquiry report done which was conducted by the SP Latehar.
With respect to the same
Yes,
charge?
yes, yes.
This is just an internal inquiry?
Yes, ma'am. This is an internal inquiry.
No, आरोपी का बचाव स्पष्टीकरण ये क्या इंक्वायरी?
ये एसपी के द्वारा कराया गया था। इसी विभागीय कार्रवाई में पुलिस अधीक्षक लातेहार का मंतव्य।
5/3/2013.
Yes, ma'am.
And this is the inquiry report is dated?
Inquiry.
9/6/2012.
Yes, 2012.
Why there was a second inquiry?
9/6/2012.
Why there was a second inquiry? Why there were two inquiries? Because it is talking about again maybe another charge.
No, this is also same 341, 342, same FIR, same everything.
Same FIR. Thanakan 60.
हाँ,
This is
थानाकांड 60/9, 60/9. इसमें भी 60/9 ही। And this time, my lord, this superintendent of police, he recommended.
why there will be two inquiry report?
In the same departmental proceeding.
Who's going to respond? ये second show cause है क्या? It is arising out of the second show cause.
It is also मंतव्य, my lord. Here it was recommended कि इनको सेवा से बर्खास्त कर दिया जाए.
मंतव्य नहीं हो, but it is apparently.
This superintendent of police perhaps recommended the DIG for inflicting the petition with
That's like
dismissal.
after giving a
Yes.
brief summary of it.
Yes, yes, yes. He recommended for dismissal. Thereafter, the DIG passed order annexure 5, my lord. Annexure 4 is my reply. Second so was reply. 4, page 29 onwards.
What are you stating?
Yes, ma'am. Page 2 of the thereafter, madam. श्रीमान मनिका थाना कांड से क्या अनुसंधानक थे, पुलिस अधीक्षक धारा परिवर्तित कर अंडर सेक्शन इतना भाजवी कर दिए। मैं उस धारा
What
को
is your main ground?
main ground that is mentioned in this appeal also is that the inquiry report was not served to me.
If the inquiry report was not served to you, how do you respond to the second show cause? Have you stated it in your second show cause reply that the inquiry report was not served to you?
Yes, it is.
Where is mentioned?
Yes, ma'am.
So the second show cause was issued without the inquiry report.
Yes, on the basis of this.
Let us see where have you taken this point in your reply to second
Yes,
show
ma'am.
cause.
Yes, that is the 26, my lord. Point number 26, page 33, internal page 5 of this reply. संचालन पदाधिकारी का मंतव्य सजा के पूर्व आपूर्ति करना अनिवार्य है, अन्यथा विभागीय कार्रवाई में पारित किए गए आदेश विसिएट हो जाता है। इस सिद्धांत के लिए सुप्रीम कोर्ट का तथा हाई कोर्ट
नहीं है कि आपको नहीं मिला है. Where have you stated that you have not received it?
only
And
this.
you are referring to so many things from the inquiry report only. You have not taken a stand that you have not been served with the inquiry. वो तो copy paste हो गया judgment से. That's all.
I don't have any better place. Appellate authority.
And punishment order?
Punishment order, then page 35.
35 is the punishment order. What is the date of this punishment order?
This is dated 3/4/2013. But his मंतव्य is important. ये last paragraph इनका जो है DIG का पेज 38 में अतएव संचिका में उपलब्ध प्रदर्शों अभिलेखों का गहन विवेचनोपरांत पुलिस अधीक्षक लातेहार के द्वारा किया गया अनुशंसा अनुपातिक नहीं पाते हुए अपचारी को 6 माह के लिए सहायक अवर निरीक्षक के न्यूनतम वेतनमान परिवर्तित किया जाता है तथा
Only for 6 months. Only for 6 months.
हाँ 6 months.
And then the effect of this order is gone now.
हाँ he is also superannuated.
तो अब क्या बचा है?
बचा नहीं मेलोड के पास में.
The counsel for the petitioner is present. Nobody appears on behalf of the respondents. The petition has been filed challenging the order dated 3/4/2013 passed by the disciplinary authority. Respondent number 3, whereby an order of punishment has been passed against the petitioner by directing that the petitioner will be paid basic pay of assistant sub-inspector for next 6 months. And during the said period, he will not be given charge of investigation. A further prayer has been made. You have not preferred appeal.
No.
The counsel for the petitioner, while assailing the impugned order, has submitted that during the departmental proceeding, proper opportunity to cross-examine the witnesses has not been given. He has further submitted that the inquiry report was also not provided to the petitioner. The learned counsel further submitted that so far as the charge was concerned, it was alleged that petitioner did not inquire into the FIR filed and registered as Manika case number 60 of 2009. The learned counsel has submitted that the trial court had passed an order dated 28/3/2011 stating that the petitioner that it was wherein it was recorded that due to lack of knowledge the petitioner had inadvertently submitted final form in the case, being convinced from the fact that he had already filed a petition for further investigation. In Manika PS case number 60 of 2009. learned counsel has, during the course of argument, has submitted that the petitioner has already superannuated from service, and he has fairly submitted that the impact of the order of punishment does not survive anymore. After hearing the learned counsel for the petitioner and going through the records of this case, it appears that the petitioner was the investigating officer in Manita PS case number 60 of 2009, dated 9/9/2009, registered under section 341/342/323/504/34 of the Indian Penal Code, and subsequently converted under section 419, 420, 406, 467, 468, 471, and 120B of IPC. While charge sheet dated 21/4/2011, it was alleged that the petitioner did not complete the investigation of the said case properly, which reflected dereliction of duty on the part of the petitioner. Along with the petitioner was asked to file a show cause, and a departmental inquiry against the petitioner was initiated. A copy of the show cause filed by the petitioner to the judge has not been placed on record. However, a copy of the inquiry report has been placed, which is dated 9/6/2012. Upon perusal of the inquiry report, it appears that the petitioner did not respond to the. It has been recorded that the petitioner did not respond to the. Did not file any explanation or response to the charge, and repeated opportunities were given to the petitioner, but the petitioner had appeared before the inquiry officer just once. The inquiry officer has recorded these aspects of the matter in paragraph number 4 of the inquiry report. And has recorded that in spite of repeated opportunities, the petitioner was not participating and was unnecessarily delaying the matter. And also consider the fact that the petitioner did not get any response to the charges. The state authority found the petitioner guilty of the charges, and thereafter note was also prepared by the Superintendent of Police Jharkhand, recommending for dismissal of the petitioner. However, the recommending for dismissal of the petitioner, it further appears that the petitioner was again granted an opportunity with respect to the proposed punishment, to which he responded on 5/4/2013. In the same reply also, such grievance has been raised by the petitioner that he had not received a copy of the inquiry report, but has simply stated that as per the law, this is simply stated in paragraph 26 that as per law, if the findings of the inquiry report is to be forwarded and has referred to certain judgments. The disciplinary authority has considered the materials on record and has passed a detailed order and has taken care of the fact that the order of dismissal would be disproportionate to the charges level and proved against the petitioner, and passed an order to place the petitioner in the minimum pay scale only for a period of 6 months. The inquiry report gives the various dates on which the petitioner was asked to participate in the proceedings, but the petitioner had been totally negligent in the matter of participation before the inquiry officer and had attended, and apparently he had attended the proceeding only once. Considering the totality of facts and circumstances and the nature of punishment involved in the present case, minor punishment?
Minor, yeah.
Minor?
Yes, ma'am.
Which is minor in nature, this court is not inclined to interfere with the proceedings, interfere with the order of punishment and finds no illegality in the proceedings.
Your Lordship, my apology. We could not come up in time. My apology, Your Lordship. I'm just giving my apology.
Apology accepted, but appearance will not be required. It's a record कर दीजिए, appearance कीजिए.
जी.
The counsel for the respondents is opposed to that.
Much obliged.
Opposed or supported?
Opposed.
Item 5, 12 PC 1450 of 2014.
Yes, petitioner. There is a petition.
Yes, Your Honor.
Yes, please.
In this case, Your Lordship, they have filed a counter affidavit on behalf of the NABARD, wherein, if Your Lordship please just have a
Let
look.
us, you are ready to argue now?
No, Your Lordship, only to that extent that the amount that has been given by the Central Cooperative Bank to the different packs, out of which we are representing 51. Information has been given to us on query, Your Lordship, that 90% of the amount granted to the ineligible persons that have already been returned. So to that effect, Your Lordship, we want to file a detailed reply.
So you just say take time, इसमें इतना bounded का कोई काम ही नहीं है. How much time do you need to respond? You just tell us how much time you need to respond.
3 weeks time, Your Lordship.
Date बताइए. बस उसके beyond what time?
नहीं.
इतना सोच समझ के time.
Here, Your Lordship, it may be placed on 12th or 13th.
आप you choose your date. कब
12
तक फाइल करेगा बताइए.
12/2.
It should be placed on 12/2.
Yes, Your Lordship.
12/2 is a Monday.
Friday.
Friday, Your Lordship, it is 16, 17, 15.
9th is Friday. February.
9th is Friday.
16th is Friday.
16th, Your Lordship.
Okay, so you want to file it by 12/2. 16th को रखते हैं.
सेंट्रल कोऑपरेटिव बैंक को भी तो काउंटर देना है.
हमको तो अभी डिजिट कलेक्शन कर रहे हैं, मुझे लोग दे ही नहीं रहे पूरा डिटेल पैक्स वाले, इसीलिए आई एम इन प्रोसेस ऑफ कलेक्टिंग द डाटा व्हिच दे हैव एडजस्टेड अगेंस्ट देयर प्लस बेनिफिशियरी. अदरवाइज जो जितना हमको रिफंड करना था
But ये never ending process है.
प्लस इन द काउंटर एफिडेविट फाइल्ड बाय द NABARD they have said that whatever we have done already.
That's it.
This is what their encounter regarding us. They have stated that we have refunded the money to the extent which we have got back from the PAX.
That's it. So what is your role now?
Not much, Milos. If it was
Now
anything
the
comes,
money is not with
Bank.
any one of you. It has been refunded.
money has been whatever we have received, we have transmitted to the PAX, and PAX had correspondingly adjusted from the loan account of the beneficiaries. At 50% only. Rest 50% has not been released by the NABARD till date. At that they are claiming that 50% they have lost waived off 100% from their loan account, but got 50% through the Belos Bank only as we received from the NABARD. Therefore, what these PACs are saying, since we have waived 100% loan amount, got only 50%, therefore that 50% should be released to us. This is the whole nut and
And what is the stand of NABARD? What stand NABARD has taken? Who's for the NABARD?
I'm for the
What is your stand?
Yes, so I along with Mr. Gyanam Kumar is appearing. NABARD stand is the Dhanbad Central Cooperative Bank has claimed 30 crore rupees, out of which 17 crore was released by the bank. By the, 17. After the CAG report and the regulatory when found, they returned 97 lakhs. That is my counter affidavit. 16
Who
crore.
returned 97 lakh? Dhanbad Central Cooperative Bank.
Dhanbad Central Cooperative Bank has refunded 97 lakhs. So 16 crore is 16 crore is still.
look at pura picture of madam. Because when the scheme was floated,
सुनिए, कोर्ट का टाइम ना यहाँ पे गपशप करने के लिए नहीं
नहीं,
है. इनको रिस्पॉन्ड करना है.
हाँ, दे दो,
आपको मिल
तो
गया है,
हम
आपको
खाली-
रिस्पॉन्ड करना है, करिए, नहीं करना है.
बट आई व्यू क्या इशू है हुजूर वो
नहीं, हम सुनेंगे बात.
जी,
ऐसे
ठीक
थोड़ी होता है.
इशू बता देना चाहते
हमारी इशू हम लोग सुनेंगे.
हैं ठीक
आपको रिस्पॉन्ड करना है तो कर लीजिए.
ठीक
नहीं तो उस दिन मत बोलिएगा कि
नहीं
आपको
नहीं हम इधर ही कर देंगे इनका जैसे आएगा एफिडेविट उसको पढ़ के दे विल सर्व द कॉपी मिलस टू मी
12 तारीख तक आपको देंगे. आपको कितना टाइम लगेगा?
हमको उसके बाद 2 हफ्ता समय दीजिए
12 के बाद 2 हफ्ता कितना? टाइमलाइन हम दे देते हैं, लेकिन अगला डेट में हम टाइम नहीं देंगे. बस इतना बता रहे हैं. 26
ठीक
Monday.
ओके. 1 मार्च को रख लेते हैं.
1 मार्च जो दोनों जनवरी वाला लगा हुआ है तो फरवरी वाला लग जाता है
फरवरी वाला भी उधर लगा हुआ है.
नहीं ये
First March, you see, I'm giving you time as per your choice, right? But if the affidavit is not filed within stipulated time, it will not be accepted. I will not accept it. Asset registry में file. WPC number 1450 of 2014, Council for the Parties Act as it. Council for the petitioner seeks time to file a rejoinder to seeks time and is granted time till 12/2/2024 to file a rejoinder to the counter affidavit filed by respondent number 1. Counsel for the respondents may file their response.
Respondent number 2 and 3 में फाइल हमारा तो हो गया.
Counsel for the respondents may file their response to the affidavit which may be filed by the petitioner latest by 26 to 24. Close this case under the heading for final hearing on final disposal on 1st of March 23. The counsels are also directed to file their short synopsis of argument, list of dates, and the judgments which they seek to rely upon by 28th of February. The timelines provided in this order is required to be strictly followed, failing which no affidavit will be taken on it.
Item 6, WPS 5671 of 2014.
In this case, I would like to file a list of dates and judgments. This is a good list.
Pleadings complete?
This pleadings are complete.
What is the matter?
Punishment.
It's a minor punishment.
Minor punishment of censure and stoppage of increment.
For how many? Stoppage of it.
3 increments. Stoppage of 3 increments. Sans non-cumulative effect.
Avail the remedy of appeal.
Yes, sir. In this, the basic thing was that I have also filed a latest supplementary affidavit on behalf of the petitioner. The basis of this departmental proceeding was institution of a criminal case against the petitioner. In that criminal case, the petitioner has been acquitted by the learned trial court.
Honorable petitioner.
It is stated कि कोई साक्ष्य नहीं मिला है. मैंने
When is the
इसका
order of petitioner?
कोई साक्ष्य नहीं है.
When was the order of petitioner passed? During the pendency of the writ petition.
Yes, yes, yes. This is.
Where is that?
This is supplementary affidavit dated 2012-2023. Annexure 13. परिणामतः उपरोक्त विवेचना के आलोक में मैं निष्कर्ष पर पहुंचता हूं कि विरुद्ध कोई साक्ष्य नहीं है तथा मामला साक्ष्य विहीन प्रतीत होता है। अतः साक्ष्य के अभाव में अभियुक्त हसनैन अंसारी के विरुद्ध लगाया गया आरोप धारा इतना तथा अभियुक्त सत्य प्रकाश ही इज द पिटिशनर मानो तथा राजेंद्र प्रसाद के विरुद्ध लगाया गया आरोप इतना संगठित धारा इतना भादवी तथा भादवी को विमोचित किया था और अभियुक्त तथा उसके जमानतदारों को बंधक
The 3 witnesses on behalf of the prosecution were not produced. In the departmental proceeding, these 3 witnesses have acted.
Your Ladyship, in the departmental proceeding, he has been punished for negligence of duty. This is a case of fraud. This was initiated after the departmental proceeding.
So it is not on the same set of facts.
On the basis,
Departmental proceeding is on a different allegation altogether.
actually today I am not reading this. Only one opportunity. Because altogether 5 cases have been listed today in this court.
आपको लगता है आपके कम केस लिस्ट होने चाहिए?
नहीं, अलग-अलग दिन होते तो
It's a pleasure that you don't have time.
different Fridays if it get listed, why not? It could be convenient.
Don't ever complain that you have more cases than you can actually handle. The counsel for the parties have present. Counsel for the petitioner has submitted that a minor punishment of censure and stoppage of 3 increments with non-cumulative effect has been imposed upon the petitioner in the departmental proceeding. But during the pendency of this case, the petitioner has been, the criminal case, the petitioner has been acquitted in the criminal case. The counsel for the respondents, while opposing the, the counsel for the respondents has submitted that the petitioner has been punished for negligence of duty and the charges against the petitioner is not the same as that of the criminal prosecution case, criminal case. And this counsel for the petitioner prays for time to prepare a short synopsis, list of dates and the judgments which he wants to rely upon. Close this case on next Friday. The needful will be done under the heading of final disposal. The needful will be done by Wednesday. So, final disposal में done. List of dates बढ़िया से बना लो.
Appearance is zero. Item 7, WPS 1867 of 2015.
This is a case of dismissal from service. There is a technical problem that in this case disciplinary authority order has not been challenged. So I will have to file an
Also,
IAP.
Your Lordship, in this case, he has not availed the alternate remedy.
No, that is order has been is there. Appellate order is here. We have challenged that.
Memorial, Your Lordship, revision.
Memorial revision is not necessary in case of termination simpliciter. It is in case of things my lord 853 of the police manual. Removal, termination, and reduction in rank.
This matter is pending since 2015. Why have you not challenged the order of the disciplinary authority?
Because
And when the case is taken up today, you want time?
actually, while going through this file, my lord, I came to because the dismissal order I have not been provided, my lord, it has been annexed in the counter affidavit. Otherwise, this case, my lord, it is not a good case because she acquired the employment on the basis of a false certificate. And that certificate was verified and it was found to be false and fabricated. Nothing much. Only ground is she is taking, my lord, there were two certificates. The police verified the certificate which she did not give, and the certificate which she gave was not verified. दो सर्टिफिकेट का बात हो रहा है दो स्कूल में. इनका कहना है कि जो वेरीफाई किए हैं पुलिस वाले वो हम दिए ही नहीं थे एक्चुअली. वो किसी और स्कूल का तो उसको वेरीफाई करके हमको डिसमिस कर दिए और जो हम दिए थे उसको वेरीफाई नहीं किया और वो जेन्युइन है. बस इतना ही केस है और कुछ नहीं.
Disciplinary inquiry was instituted, no?
Yes, Your Lordship.
There has been a proper proceeding. What was your stand?
She did not participate. That is.
Very. Why didn't she participate? ऐसे करिएगा. Why she did not participate?
She was noticed, but she did not reply to any of those things. Her only common plea, inquiry report and cross-examination. The certificate which she wants to be verified has not been verified.
Did you move earlier
No.
before this court? How do you say no? Who gives you this information?
This is the
What happened in that criminal case?
it is pending.
What is the case number? What is the case number of the criminal case?
Your Lordship, it is Baryatu Gonda Thana, Kand Sankhya 194 of 2012.
Baryatu,
Gonda,
Gonda,
Thana Kand Sankhya 194 of 2012, dated 28/7/2012.
194 of
2012,
2012.
dated 28/7/2012.
Are you aware about the status of this case?
Your Lordship, it is not apparent from the counter affidavit. We have to take the present status, check the
From
present
where did you take the present status?
by
E-court services.
E-court service में मिलता है ना? फिर क्या सोच रहे हैं?
check कर देते हैं हम.
करिए चेक. पास ओवर 10 days. इतना टाइम नहीं है कि जाके पूछते रहिए, फोन करते रहिए. This is very simple. Find it out.
Item 8, WPC 774 of 2016.
Your Ladyship, I am seeking adjournment as the senior is not in the premises.
Your Ladyship, I am also paid for 1 week time. File is not with us, so we reconstruct the file, Your Ladyship.
Rajendra Krishna.
You see, in my court, there is a procedure. Whenever you want to seek adjournment, you have to give advance notice of adjournment. Right? You should know this was a procedure followed earlier. Otherwise, I impose cost on adjournments.
Sorry, your next.
That is the rule of court number. This is court number 11. That is the rule of court number 11.
Yes, your lordship.
So when you want readings complete, you are without the file.
No, no, your lordship. I have the
Readings are complete.
No, your lordship.
No,
No. He still
readings
has
are not
to.
complete.
He still has to argue this case.
So pleadings are complete.
Yes,
You
your
know?
lordship. Yes.
Pleadings are complete.
Yes, yes.
You give her a copy of the brief. Today. Counsel for the parties are present. Counsel for the petitioner, Mr. Your name?
Ayush Srivastav.
Ayush
Srivastav.
Srivastav. Samit said this matter has to be argued by Mr. Rajendra Krishna, who is not available in the court today. Correct? दूसरा जगह clearance नहीं चल रहा है. Post this case on when do you want?
Any day, your lordship.
Any day मत बोलिए. आप choose करिए बैठिए. क्योंकि अगला डेट में हम टाइम नहीं. आप अपने सीनियर से पूछ लीजिए डेट पे on a Friday.
Next to next Friday, your lordship.
Next to next Friday is 26th. You want to do it?
Yes, sir.
26th January.
27 might be.
27th. On Saturday?
I did not see the calendar, your lordship. 2nd February, your lordship.
2nd February.
Second,
Right?
yes.
With the consent of the counsel for the parties, post this case on 2nd of February 23. It has been submitted that the pleadings are complete. The counsels are directed to find their synopsis, list of dates, and written notes of argument. The synopsis, list of dates, and the judgments which is to rely upon. Latest by 31st of January 23. No further adjournment will be granted. If your senior is not there, you will bear it.
Item 9, WPS 890 of 2016.
Yes, please.
Thank you, Lordship. In this case, I want to request short notes of argument lead subject.
Every case does not.
Pleadings are, I will argue on 19th.
Every case we don't need short notes of argument. You tell us what is your case.
For monetary compensation, petitioner's husband died in Harris on 10/4/1991. And this is second round of litigation, Lord. Which is I have annexed
Earlier order.
earlier order is annexed for page 23. Concluding portion is at page 25. Married concluding portion.
Yes.
At page 25, last paragraph 5-6 line से
पूरा पढ़िए.
पूरा last paragraph. Different pleas or documents which are being sought for in order to proceed the claim will not absolve the respondent's CCL or statutory liability to pay the gratuity amount of the deceased employee to his nominee. Respondent's CCL would take a decision of payment of the gratuity claim of the petitioner and make payment thereof within a period of 10 weeks along with statutory interest. So for claim for life cover scheme CNPF amount and family pension are concerned, the respondents would take a decision on that in accordance with law within a period of 10 weeks from the receipt of a copy of this order, along with detailed representation annexing the relevant document and paper on behalf of petitioner. The admissible amount towards life cover scheme should be paid thereafter without any unreasonable delay. If the claim of provident fund and family pension is found to be admissible by the respondent CCL, then necessary papers thereof be sent to the respondent number 6 thereafter without any delay so that the claim of CMPF family pension amount may be processed and settled in favor of the lawful claimant as per the terms of the CMPF scheme. Now this is important. So far as claim of the monetary compensation is concerned, it does not appear from the document that any such an application was made by the petitioner.
Where is the rejection of the claim?
It's not Annexure 6, page 28.
Read
This in relation to the subject case aforesaid, whereby and whereunder the Honorable High Court has been pleased to give liberty to yourself to make an application for monetary compensation claim, which may be considered in accordance with law. Further, the Honorable High Court has also observed it does not appear from the document that any such an application was made by you at any point of time after the date of the employee. Now you have filed an application addressed to the project officer.
At that point of time, there was no provision for payment of monetary compensation. How will you get it?
But this is beneficial, kindly, I am relying upon a judgment, passed by this.
Was the NCWA given retrospective effect?
In this case also, Lord, at that very time,
Can you read the judgment that you had?
this script doesn't have some
Read it, please. दो पन्ना का order
heard counsel for the parties. The petitioner has approached this court for grant of monetary compensation in terms of the scheme of respondents. It is admitted position that husband of petitioner had died in harness on 23/3/1989, and in my case, died in 1991. The application had been made for grant of compassionate appointment, and that has been conceded by order dated 27/8/1991 in favor of petitioner. Subsequent incident has taken place, and finally order for compassionate appointment has been withdrawn. Monetary compensation has been given with effect from 1/5/2008. The only controversy now involved in the date for the petitioner is entitled for monetary compensation are circular dated 13/14/2/1995. Between NCWA FICA has been produced, which covers the field. The relevant portion of the circular dated 13/14/2/1995 is quoted herein below. In this connection, it has now been decided in the CMD's meeting held on 8th February 1995 as under. Number 1. The above benefits will also extended to the female dependents of executive. In case of female dependents of non-executive or executive employees who have already joined the service of the coal company and have served for a few years may also be allowed to opt for cash compensation if they so desire. The guidelines for regulating the monetary compensation already circulated by our letter number so and so dated 12/19 December 1994 as reproduced below. The payment of monetary monthly basis will be made from the first day of the following month from which the application by the widow of the female dependent was made for employment or each compensation. The payment of pension of the cash compensation in lieu of employment will be made till the widow of the female dependent reaches 60 years of age or death or remarriage, whichever is earlier. The cash compensation amount will be paid by money order or through a bank draft to the place of settlement of the dependent without deducting charges for money order or bank draft. Thus, the law is clear that the widow of the deceased employee will get the monetary compensation from the date of application made for compassionate appointment. In view of the above, the scheme, the present writ petitioner is allowed, and it is ordered that the petitioner will be entitled for monetary compensation with effect from 27/8/1991. The petitioner is directed to file a detailed representation before the general manager, Kusunda area, so and so, respondent within a period of 4 weeks. Now, Lord, and this writ is challenged by filing a LPA, by the respondent BCCL, and which have been later on withdrawn. That monetary compensation have been given to the petitioner, which I have also supplied, LPA number 281 of 2020. So, my lord, here also, my lord, seeing the beneficial, my lord, circulars, my lord, this widow lady also may be
What is the
granted.
date of death?
Date of death, my lord, 10/4/1991. At that time, my lord, petitioner's son was, my lord, minor, and therefore, my lord, he has submitted, but later on it was advised by the Annexer 1 that he shall apply once he gets majority. That letter is also, my lord, annexed as Annexer 1, my lord, 2, my lord. And thereafter, attaining majority, my lord, he has applied for a compassionate moment, which is not considered, and later on, my lord, writ was filed, my lord. And it is observed for
What do you have to say?
In this case, reasoned order has been passed. In
You answer to the orders produced by him?
Lordship, that I have to inquire about, and there are other order judgment also, Lordship, by this honorable
So
court.
you produce all the judgments, and if there is a conflict of judgment, we will refer it to a larger court. We'll refer it to DP. We can't help it. We cannot have conflicting orders in the same court.
Lordship, that I have to
You inquire it from CCL, BCCL, whatever orders have been passed in the case of monetary compensation with regard to the period involved, with regard to retrospective effect, with regard to entitlement.
In
the
this case,
cut-off
our
date.
stand, Lordship, at that time there was no scheme for monetary benefit.
But by this court,
The order has been passed. I have first time I have seen this order,
Yes.
Lordship.
Yes, and in the LPA, the case was not decided on merits in LPA.
No, at that time LPA
It was,
amount has been disbursed.
The amount was already disbursed.
So I have to seek instruction and I have to
And if
see.
you are able to produce anything which is clinching and has not been considered in the or placed before the learned single judge who has passed this order, we will record it and place it before the judge. So it is your duty to place all the orders in condition. Right? The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that. The petition had moved earlier before the court in WP S number 7831 of 2013, wherein inter alia a direction was issued with regard to claim of monetary compensation, and this court observed, with regard to claim of monetary compensation, this court observed that from the documents placed on record, there was no such application made by the petitioner at the relevant point of time when her husband died way back on
91.
10/1/1991.
10/4/1990.
10/4/1991. The learned counsel submits that pursuant to the order passed by this court, a representation was filed, but the claim with regard to monetary compensation has been rejected by the interim order dated 9/5/2016 by recording that in NCWA Roman 4, which was applicable at the time of death of the husband of the petitioner, there was no provision for payment of monetary compensation in Central Tollways Limited. The learned counsel has submitted that the National Tollway Agreement is applicable to all the subsidiary coal companies of Coal India Limited. He has produced a copy of the order dated 1/4/2019, passed in WPS number 1340 of 2009, wherein Bharat Coking Coal Limited and their authorities were the respondents, and has submitted that that monetary compensation was provided in case of death in harness as back as on death in harness of the employee on 23/3/1989. He submits that a latest patent appeal was filed against that order being LPA number 281 of 2020, but during the pendency of the LPA, the order of the late court was complied. The learned counsel submits that since it is a beneficial NCWA is a provision incorporating beneficial provisions for the employees slash the family members of the employees. Therefore, the improved order dated 9/5/2016 calls for interference. The learned counsel appearing on behalf of the respondents has submitted that he shall examine the matter and also place on record the various other judgments which have been passed by this court by from time to time in connection with payment of monetary compensation, particularly with regard to the time when the husband of the petitioner had expired. And we also apply this court if there is any different view taken by any other bench of this court.
Lordship.
कितना time लगेगा?
At least 2 weeks, Lordship.
Close this case on 2nd of February 2023. The required affidavit be filed latest by 31st of February 2023 by annexing a copy of the various orders. तुमसे पूछ लीजिए, Mr. Das से पूछ लीजिए,
Lordship, examine कर लें.
और Mr. अमित नाम है उनका?
अमित कुमार सिंह.
Who appears in case, Lordship, in the earlier case, Lordship.
Mr. A.K. Mehta की जूनियर
जी,
अमित
जी,
कुमार सिन्हा.
वही अपीयर हुए थे।
हाँ
वही है.
रेट में के
कंटेंट के चलते हुए नहीं कंप्लाई कर दिया ऑर्डर, वो भी देखिए। Anyways, we will see what is to be done. एक को मिला है तो सबको मिलना चाहिए। You can't be subjective.
Item 10, WPC 1437 of 2016.
Lordship, the present petition has been filed with a prayer for making correction in the Khewat, in which my caste has been changed from Munda to Lohari, Lordship.
Earlier it was recorded as Munda.
Yes, Lordship.
How has it been changed?
Lordship, in the cadastral survey of 1906, it is specifically stating that the caste is Munda. However, when the petitioner approached the competent authority for a caste certificate, then they said that your caste has been changed from Munda to Lohar. No specific reason was given at that point of time, and then he applied. He applied for Khewat, that is the new Khewat, and in 1930 it has been changed from Munda to Lohar. Without
In 1930.
in 1930.
Anything which has been changed as back as in the year 1930.
Yes, Lordship.
Then you need to go for a declaration about your caste, or there has to be a what all
Lordship.
documents or what all materials do you have to substantiate your caste?
Lordship, only the caste has been changed. Entire all the other things are same.
In India, caste comes before the name.
Yes.
Right?
Yes, Lordship.
Caste is a very important identity in our society.
Yes, Lordship.
May I amend? They have annexed the caste certificate also.
Yes.
At Annexure 3.
Annexure?
3. At the writ petition. At page 19. And wherein it has been stated that the petitioner belongs to caste Munda.
Yes, Lordship. So
My
this
lord, my
caste.
lady-
Yes, please.
Where is the caste mentioned?
The caste is mentioned in ladyship.
Third line.
Third line, the member of Munda caste, oblique subcaste, under scheduled tribe.
Your Lordship, this certificate was issued when I produced the earlier Khewat, 1906. When I produced that Khewat, my caste was recorded as Munda in the caste certificate as well. My prayer is, your Ladyship, that the Khewat, the the caste that has been changed in the Khewat of 1930, it may be changed.
Ladyship, for a, if I may. It is a question of maintainability of a petition also, because as per CNT Act Section 87, ladyship, and 91 also, the petitioner, if aggrieved from any entry in the records of rights, he has a remedy before the revenue officer.
Yes, Your Lordship. But the thing is that that remedy has to be exercised from the date of discovery within 5 years. The only thing is that we discovered from the date of discovery we have filed this writ petition. My only prayer is that liberty may be given. And
When did you come to?
in 2016, Your Lordship, we filed this writ petition.
These petitioners,
The caste certificate was issued.
just a moment. Your father was ever issued any caste certificate?
No, no, no.
Munda by caste. Permanent resident of the name of this Vishram and Dasa, your father, etc.,
Yes.
is mentioned in that paper.
Yes, yes, Your Lordship. My ancestors' names are mentioned. I am the descendant of that family.
Then how in 1906 when caste was recorded as Munda,
Yes.
how did it get changed?
That is the thing they are not answering. That is not, as it is as back as 1930, we are also not having any knowledge regarding that. But we were having this Khewat, and as per this Khewat, it is Munda.
Munda to Lohar.
Yes. And the entire village is of Munda Khudkat. And no other caste is present in that village. Only Munda is there. And how it has been changed, that is also not evident from any of the documents. Only it has been mentioned in my Khewat that has been published in the year 1930. We were not having the knowledge of this Khewat of 1930.
Ladyship, their grievance can be redressed if this is disposed with a liberty to condoning the
1930 entry, you have to be very careful what kind of remedies they can have. But this, when was this caste certificate issued?
In the year 2015. Issue date is 4/10/2015. And we filed the writ in 2016. As per
Earlier it was given as Munda on the basis of that.
Yes, yes. When we showed the 1906 Khewat.
Counter filed?
no millage.
You filed a counter.
Ladyship.
WPC number 1437 of 2016, counsel for the parties are placed, the counsel for the petition has submitted that a caste certificate dated 4/10/2015 was issued to the petitioner mentioning the caste of the petitioner as Munda.
Petition
This
number
was
2.
issued on the basis of
Annexation number 1.
the record of rights conducted as back as in the year 1996. 1906, wherein the name of ancestors of the petitioners has been recorded. The learned counsel submits that. Later on in the year 1930, the caste has been entered as Lohar, and the petitioners came to know about it for the first time when
They applied for the caste certificate.
fresh.
Yes.
When
In the year 2015.
in the year 2015 में तो आपको मिल गया मुंडा का.
After, yes. इससे पहले हम लोग को पता चला, Your Lordship, when we approached for the caste certificate, the exact date is not there. It may
Nowhere in the petition they have stated as to when this discovery was made.
And later on they came to know that the caste in 1930 records has been mentioned as Lohars.
That annexure 3 is of petition number 2. My apologies. interfering in between leadership. That is
The counsel for the petitioner, the counsel for the respondents has submitted that the petition has a remedy
under section 87 and 91.
under section 87 and
91
91
of
of the Tobacco Tenancy Act.
They can move before the revenue officer.
And they can move before the revenue officer for
Correction in the records of rights.
appropriate correction. But before disposing this case on the basis of alternative remedy, the counsel for the respondents is directed to seek instructions and file a counter, a short counter affidavit in the test case.
Your Lordship, only one correction. It would be 90 instead of 91.
It is not
90.
90. Section 90 of this.
90. 90.
कितना टाइम लगाएंगे आप? एक शॉर्ट काउंटर फाइल कर दीजिए. देखिए बहुत सारी चीजें ना, कास्ट सर्टिफिकेट इज अ वेरी टेक्निकल थिंग.
Definitely, that is, we are not, I'm not objecting to it, but leadership.
1930 का एंट्री को डिसलॉज करने के लिए बहुत ऑब्जर्वेशन देने के लिए भी बहुत सोचना.
That is why my leadership
That
section
is
9.
why you file it.
Section 90 specifically says about that. Ki if any
You just whatever you have to say, you put it in the
4 weeks.
4 weeks.
It's an old record of rights, my lord. Leadership.
रिकॉर्ड ऑफ राइट थोड़ी चेक करना. रिकॉर्ड ऑफ राइट तो सब लगा दिए आप.
Yes, yes. I have notes.
Pose this case on 16th of February 23. The counter affidavit should be filed latest by 12th of February. Put this case under the heading of time disposal.
Much.
Obliged.
लोहार से मुंडा बनाना इतना आसान काम नहीं.
हम मुंडा से
झारखंड में ही हम लोग हैं.
Item 11, WPC 1450 of 2016.
Yes. Not today. Tomorrow.
Next.
Not today means Friday. क्या मैटर है? बोलिए. What is it? What is it?
File is
Not the file also. Are you aware that you are all online? So you should be very careful when you say you do not know, you don't have the file, you are not aware of the facts of the case. You are the file?
Also, in this matter, he is praying for quashing of an order passed by Deputy Commissioner, whereby he is claiming that his Rayati land has been converted. Also, in this matter, also counter has not been filed. There is
File or counter? Who says counter has not been filed? Counter has been filed.
on my record.
Your records will not determine my records, right? Respondent number 1, 2, 3 has filed a counter.
I will reconstruct what's it.
Counsel for the parties are present. दोनों के पास फाइल नहीं है, काउंटर नहीं आती. There is a petition for substitution, perhaps it has been allowed.
Yes, one IA has been.
Counsel for the petitioner seeks adjournment. on next Friday and then we will final discussion.
अपीयरेंस दे दीजिएगा अपीयरेंस
Item 12, WPC 1474 of 2016.
Consider appearing on behalf of the petitioner, suddenly the court is pending. It will be on next week.
What happened to the petition?
Sudden death of arguing considering Mr. Niranjan, he will argue the case and sudden death of his family member. Next week, any date.
Number five. Advocate sees misdemeanor on the ground of imprisonment in the family of the counsel for the petitioner, Mr. Niranjan Singh. He submits that the matter will proceed in the next week. Counter file of, do you need to file a counter?
Lordship, this matter relates to the Jharkhand State Information Commission as well, and learned counsel is appearing. The file.
But I will examine your lordship because your lordship old matter and I have also no copy of the REIT application. He will provide the copy of the REIT application, your
They will
lordship.
not provide you anything. If you don't have, you take certified copy.
Pardon.
If you don't have, you take certified copy that is available.
Pardon. I will examine your lordship.
You cannot have the luxury of losing your files. If you want to apply for entire records.
Pardon, I will arrange your lordship. I will arrange. From the state council, I will take.
Counsel for the respondent number. RTI है ना?
My lord, respondent number 2, your lordship.
Respondent number 3 को notice हुआ है. Who's for respondent number 3?
My lord, whether
Lordship, I am appearing.
Respondent number 3. The counsel for the respondent number 3 is present. Counsel for respondent number 1 and 2. Praise for and is granted time till 2nd of February 23 to file a counter affidavit in the present case. Rejoinder, if any, by 9th of February, post on 16th of February under the heading of final discussion.
my lord, in fact, your lordship, the respondent number 1, he has made a state of Jharkhand through Chief Information Commissioner.
No, you just seek instructions
But
from,
I will see.
you seek instructions from
My lord.
information. You file a counter, respondent number 3.
No, we are not.
In the meantime, within the appropriate time, it will be open to the respondent number 3 to file a counter.
Item 13, WPC 1497 of 2016.
Excuse lordship, an application.
Counter आया नहीं ये लोग time मांगते हैं. Yes.
Excuse lordship, the application order 6 rule 17 was filed lordship in a suit lordship for the amendment of the plaint, and that was subsequently rejected. Now lordship, the case as per the plaint is that on the ground lordship that it will change the nature of the suit. Now lordship, I am just narrating the fact what was in the plaint and what amendment we have sought for lordship in the application which has been filed in the learned trial. The suit was filed lordship.
The suit is pending.
It's pending.
Suit is 1 of 2007, Lordship. I pray, Lordship, status report may be called for,
I
Lordship.
have got an instruction day for yesterday from the court bureau's counsel.
Okay.
It's still pending for evidence. Now, Lordship, what has happened in this case?
Pending for evidence.
Lordship, the thing is that Lordship, permanent injunction suit was filed for restraining the defendants from the suit land for interfering the suit land. It is Lordship 6 feet wide and 122 feet in length. That is a strip of a land, Lordship. My suit premises, I have got a land registered the land registered on which Lordship we have constructed a house. 6 feet wide passage was left out, so that for the air, electricity, other things, Lordship, and a chhajja is proper property inclusion. That was on my land which we had left. Now, Lordship, what has happened prior to the filing of the suit? They tried to, the defendant is my neighbor. He tried to encroach upon that 6 feet passage. We filed, thereafter, Lordship, 144 proceeding was initiated. By that, Lordship, there was a restraint against them, and therefore they could not make any encroachment over the land. In the meantime, since that was a cloud over my land, therefore I filed a suit wherein Lordship application for the suit was filed for permanent restraining the defendants, since I was in possession over that strip of land at that time. What happened, Lordship? We had filed an application for temporary injunction also, Order 39, Rule 1 and 2. That was rejected by the trial court. When we preferred an appeal against that limited order, the status quo was maintained by the learned district judge, and they were not interfering in the position. After some time, when that miscellaneous application was taken up finally by the learned district judge, the same was dismissed. Now, taking advantage of that position, since it was dismissed and the suit was pending for final adjudication, taking advantage of that, Lordship, they have made construction just by side of my wall. They have erected an entire wall over the suit land. Therefore, Lordship, I filed an application stating all these facts, that during the pendency of this suit for permanent injunction, they have entirely encroached upon.
Recovery of possession.
Yes, therefore, Lordship.
So therefore, the reliefs are totally different.
Lordship, what I am submitting in this case, since Lordship,
every subsequent development does not necessarily call for amendment to be allowed. It's a different course of action also.
That is what I am submitting, Lordship. Yes. It is during the pendency of the suit. It is not that
during the pendency of the suit, many things may happen.
The thing, Lordship, what the trial court will be deciding is only on the strength of my sale deed. Whatever, if permanent injunction is also granted or refused, that will be on the strength of my sale deed. Or even if the recovery of possession that will be granted or refused, that will be on the strength of the sale deed. And the sale deed is the main thing.
There is no relief for recovery of possession.
Therefore,
because
Lordship,
you were seeking permanent injunction.
Initially, Lordship.
In the meantime, your temporary injunction was rejected ultimately by the district judge.
Yes, Lordship.
That relief was rejected, and subsequently you have been dispossessed from the property.
Therefore, Lordship, what I am submitting, that since the entire thing has to be decided on the basis of the sale deed, whether the sale deed which was purchased by me on the other land of the sale deed, only 6 feet strip is now there to be decided whether this comes under the same sale deed or not. If it is under the same sale deed, the relief can be granted either for permanent injunction or for recovery of possession. In a subsequently, Lordship, what has happened, I have been dispossessed. Therefore, Lordship, my application was for amendment that this prayer may be allowed to be incorporated in the print, so that that thing also can be decided within a trial court. And for that, Lordship, I am also relying upon some judgments.
It is not a case of declaration of title and recovery of possession, or you have been dispossessed during the pendency of declaration of a title suit. Right?
Even for permanent injunction, Lordship, my right title will have to be seen. And on the strength of my right title and interest, only, Lordship, the relief can be given to me or refused to me. Not otherwise. I cannot come.
Petition seeking amendment.
Lordship.
Page 31, Lordship. Annexure 1.
26.
Page 26, Lordship. The plaintiff filed the suit for permanent injunction, restraining the defendants from interfering or disturbing the destruction or destructing the plaintiffs from exercise of the possession over the suit land. Soon the defendants came to know that the plaintiffs had filed said suit against them. They started making construction over the suit land. The plaintiff thereupon filed petition under 39(1)(2) for the temporary injunction till disposal of the suit. The defendant files his show cause, and after hearing the learned munsif, dismissed the petition by order dated such and such. The defendant, in disregard of the order of the status quo, thereafter miscellaneous appeal number such and such before the district judge Palamu, the learned district judge ordered to maintain the status quo by the order dated 12/3/2007. The defendant disregarded the order of the status quo and started construction over the suit land and on 17/3/7, thereupon the plaintiff filed a petition under 39 Rule 2A, white miscellaneous case number 39. That is, Lordship, for the non-compliance of the order, Lordship. Therefore, 2A petition was filed. That against the defendant, after disregard the court's order, again started construction over the suit plan on 20/10/2008, and again the plaintiff filed a miscellaneous case on 21/2010. After hearing the miscellaneous appeal number 2/2007, the legislature dismissed the appeal on 10/12/2010. The defendant, taking advantage of the dismissal of the appeal, again started construction over the suit land, 3 feet and 122 feet, and due to this illegal construction over the suit land, the chhaja of the plaintiff broke down and all the windows were completely blocked. That due to this illegal construction over the suit land, the nature of the suit land has changed. The suit has changed, and that due to the change of circumstance, the decree of the suit became fruitless. So it is necessary to amend the plaint. That due to the subsequent event during the pendency of the suit, also due to the change of the circumstance, it is therefore necessary to amend the plaint. There is a direction of the apex court reported in such and such. Proposed amendment. In the last line of para 13, for the word hence till the end may kindly be deleted. Para 14 and 15 may kindly be deleted and substituted by the following paragraphs. That during the pendency of the case, the defendant started construction over the suit land, and the plaintiffs immediately filed a petition under Order 39, Rule 1 and 2. The defendants filed show cause.
Change the nature of the suit completely.
Lordship?
You yourself stated that due to the suit land is changed, the nature of the suit land has changed. You are saying so.
Notice what I'm just.
Page 28. Page 28, para 8.
Where is the impugn order?
Impugn order is page annexure 2, page 34.
Starts from page 34.
There is a stay in this case.
No stay.
There is no stay.
Yes, this is under 227 minutes.
227.
Page 36.
Lordship. Page 36, Lordship, in the light of from the
During the hearing.
Lordship. During the hearing, the learned counsel for defendant submitted before the court that this amendment changes the entire nature of the suit, so that amendment cannot be allowed. This amendment is directly in contravention of the Code of Civil Procedure. In light of the rival submissions, I have perused the record. On perusal, it transpired that initially the case was filed by the plaintiff for permanent injunction, and thereafter the miscellaneous petition was filed for getting temporary injunction, but the petition of the defendant was rejected by this court as well as by the appellate court. Now the plaintiff has sought amendment of the entire plaint and has proposed several amendments in this petition. But when I go through the amendment, I clearly find the amendments have totally changed the nature of the suit, and it's directly in contravention of the court. The judgment filed by the learned counsel for the plaintiff are before of 2012, and in the year 2002 the Code of Civil Procedure were amended. It is a subtle principle of law that the amendment cannot be allowed if it changes the entire nature of the suit. Admittedly, the plaintiff has filed the suit for the injunction, and now he wants to convert it to the title suit. So it is quite clear that if the amendment would be allowed, it could change the nature of the entire suit.
Any legality in this order? It is changing the nature.
Lordship. I'm just relying on two judgments, Lordship. Para Lordship. In 2019-15 Lordship. Para Lordship. Para 9 onwards Lordship. Several judgments have been reported thereafter. The second judgment Lordship which I have given, J.J. Ram Manohar Lal, is of 1969, that has been also been incorporated in this judgment Lordship of 2019 judgment.
This is post 2002, no?
Lordship.
This is
Post 2000.
पूरा 96.
नहीं वो जो हम बता रहे हैं this judgment which has been I have like second judgment Lordship, 2019 judgment. This judgment Lordship incorporates all those judgments Lordship.
You just tell us that what was the fact of this case?
The fact Lordship of 2019.
Yes.
In this case Lordship, the suit was filed by some individual. Thereafter Lordship, he wanted to change the nature of the suit by a company. And that was considered, an entire judgment in paragraph 9(8) onwards, Lordship, has been considered. That will suffice, Lordship, and the entire thing will suffice. Judge Ram is also quoted in 22, Lordship. At page.
Changing the party position is not the same thing.
All the things, Lordship, has been considered. Whatever I am submitting, everything in those judgments are there, Lordship, and thereafter, Lordship, can pass it.
Is there any judgment which says that suit for permanent injunction
Can be converted into a title
is
suit.
there any such judgment?
That I'll go through.
I'm going to
That's whatever.
Learned counsel for the parties are present. This petition has been filed under Article 227 of the Constitution of India, challenging the order dated 16/12/2015, passed in title suit number 1 of 2017, whereby the petition seeking amendment under Order 6 Rule 17, read with Section 151 of the Code of Civil Procedure, has been rejected. While giving the background of the case, the learned counsel for the plaint you have not filed.
That I have not filed, Lordship, since the entire thing is there in the.
The learned counsel for the petitioner has submitted that, upon a query of this court, the learned counsel for the petitioner has submitted that the plaint of title suit number 1 of 2007 has not been filed. However, the petition seeking amendment has been filed. He has also submitted that a petition for that the suit was filed for permanent injunction,
Lordship.
and another petition was filed in the suit under Order 39 Rule 1 and 2 seeking temporary injunction, which was rejected, and thereafter an appeal was filed in which status quo order was passed, but ultimately the appeal was also dismissed. However, on account, in which order of status quo was passed on 12/3/2007, an appeal was ultimately dismissed on 10/12/2010. In the meantime, a petition was also filed on account of non-compliance of the status quo order, and the said petition was also dismissed subsequently.
Along with the appeal.
Along with the appeal. The learned counsel submits that in the meantime the petition has been dispossessed from the land, and the respondents have made pakka construction over the property, and therefore he filed a suit. He filed a petition seeking amendment for recovery of possession
Lordship.
of the suit property. The learned counsel has submitted that the amendment was filed on account of subsequent development, which ought to have been allowed by the learned court below, but having rejected, the present petition has been filed. The learned counsel appealing on behalf of the respondents has opposed the prayer and has submitted that the
himself admitted the nature of the supplant had been changed.
admissions are nature. The learned counsel for the respondents has submitted that the nature of the suit will change, and merely because there is said to be subsequent development is not sufficient to allow an amendment. He has also submitted that he has also submitted that the suit is still pending and it is at the stage of
Evidence.
After hearing the learned counsel for the parties, the facts narrated by the petitioner is not much in dispute, but the records indicate that a petition for permanent injunction was filed, in which a petition for temporary injunction was also filed, which was rejected, and ultimately the appeal against the same was also dismissed. Dismissed on 2010.
Not sure.
Amendment of file.
Amendment not filed on 16/2/12 also.
Was dismissed on date बताइए sir.
Dismissal date not sure. Dismissal.
उसका
A miscellaneous appeal.
हाँ.
That is date lordship 10/12/12.
10/12/2012, and the amendment was filed on
No, 2010 lordship. 10/12/2010.
10/12/2010,
And the amendment was filed on 16/2/12 lordship.
16/2/2012. This court has gone to the impugned order and finds that the learned court has rejected the petition seeking amendment on the ground that if the amendment is allowed, the same will change the entire nature of the suit, and has also observed that by seeking amendment, the petitioner has sought to amend almost or amend the entire page. After having gone to the impugned order, this court is of the considered view that the amendment sought for in the present case would change the nature of the suit, and now the petitioner would be seeking recovery of possession based on his claim of title over the suit property. And accordingly, this court finds no error in the impugned order calling for interference under limited jurisdiction and Article 227 of the Constitution. Since the suit is pending since 2007, get a copy of this order be communicated to the concerned court for expeditious dismissal.
Passover case item 1, WPS 4956
The
of the
cases will be
Constitution.
taken up after this Passover, so don't leave the court. 4:30 बजे के पहले कोई उठने वाला नहीं. Yes, who is there for the petition? Are you there in this Passover matter?
At the time, I have not come to the please, last occasion, my lord. The petitioner directed to file an amendment petition, which was filed in the LPA, my lord. That was filed, my lord, by annexing the amendment petition.
You filed an amended petition.
IA number 2554, the annex कर दिए जिसमें
Supplementary counter affidavit has also been filed.
Yes, ma'am.
Yes, amended writ petition has been filed.
Yes, ma'am.
Right?
As annexure 70.
Annexure 17.
Yes, ma'am. Read के बाद में annexure 70.
Supplementary counter affidavit has been filed.
Yes.
petition.
Yes, ma'am.
This is a very amended petition. You have filed a reply, supplementary counter affidavit.
Yes, Your Lordship. To the amended writ petition.
Amended. Yes, filed on 15/6/22. When did you file a reply?
Your Lordship, it has been filed on
No.
इसके बाद देखिए बता दीजिए। 15/6.
7 November 2023.
23. There is a supplementary affidavit also.
Yes, supplementary.
Supplementary counter affidavit. Dated. There is a supplementary affidavit also you have filed. 9/11. Alright, they have filed a counter affidavit. What do you want now?
I have not received my counter report.
Without receiving, how can we file?
Asif Paran Mehto, advocate for Swapna Majhi. He's your very good friend. I know. A.B. Mahato is a very good friend of Swapna Majhi.
But in my file, that was not my product.
So don't tell me that you have not received it.
I'm sorry, madam.
You give him you take a copy from him during the course of the day. You have a copy?
Yes, Your Lordship.
Counsel for the parties are present. Counsel for the petition submits that amended petition has already been filed. The counsel for the respondents, supplementary counter affidavit has been filed pursuant to the amended petition. Counsel for the petitioner prays for and is granted time till 25th of January 23 to file a rejoinder to the supplementary counter affidavit.
When, madam?
25th January. There are,
But 25th January, by 2nd February.
oh, by 2nd of February 2024 to file a rejoinder to the supplementary counter affidavit. Close this case on 9th of February 23 under the heading for final disposal. Synopsis, list of dates and the judgments the parties are seeking to rely upon should be filed by 7th of February 23. Right? The timeline is required to be followed strictly.
Appearance Password case item 7, WPS 1867 of 2015.
Mr. Krishna, are you there?
Your Lordship, this case is still pending. It is showing that it is for appearance.
Pending for appearance.
For appearance,
You're not appearing.
no, appearance. Sometimes it shows anything.
Shows anything.
Yes, because I have tested that e-code service.
That is why this code, you have tested it. It's a very serious
E-code.
allegation of the court system.
Because I have appeared there and it was still showing a appearance and but one thing can be done that subject to outcome of that criminal case if this petition, or I shall be given liberty to approach after, because everything depends upon that criminal case.
No. Who says that everything will be
Because
principles are totally different.
two certificates, issue is between two certificates, which one is genuine? If the department which is saying this certificate is genuine, then I have no case. And if the certificate which I am claiming is to be
Which
genuine,
all are the two certificates? Have you annexed it?
yes, the certificate which I am claiming has been annexed.
Where is it? Tell us where is it?
It is not there.
हम लोग तो यहीं से इंक्वायरी करा जाएगा आएगा और डिस्कस नहीं आएगा तो आपके फेवर में आएगा सर्टिफिकेट भी know the consequences. If you say that this is genuine and if it is found to be forged, you know the consequences.
Yes,
Another criminal case.
Yes. Otherwise, there is nothing in this case. Same.
आसानी से गिव अप नहीं करते हैं क्या
ऐसा केस ही सब लग गया है. And disciplinary authority order is also not changed.
Where is the order of the appellate authority?
This is page 27. And except 4, page 25 onwards. मैं रीड विज्ञापन संख्या 1-10 के तहत रीता कुमारी वन शिव कुमार ओझा क्वार्टर नंबर इतना सो वरीय पुलिस अधीक्षक के कार्यालय ज्ञापन दिस के द्वारा प्रधानाध्यापक के मध्य विद्यालय रंगमटिया सिंदरी धनबाद को पत्र भेजा गया था. प्रधानाध्यापक के मध्य विद्यालय रंगमटिया सिंदरी धनबाद द्वारा भेजे गए शैक्षणिक प्रमाण पत्र की छाया प्रति पर अंकित कर सूचित किया गया है कि रीता कुमारी का कार्यालय अभिलेख के आधार पर टीसी गलत पाया गया. उक्त परिप्रेक्ष्य में वरीय पुलिस अधीक्षक रांची के कार्यालय ज्ञापन संख्या इतना का दिनांक दिसंदेश सनी शंकर प्रसाद माझी को के मध्य विद्यालय सिंदरी धनबाद जाकर जांच करने का निर्देश दिया गया है कि उक्त शैक्षणिक प्रमाण पत्र सही है अथवा नहीं. उक्त निर्देश के आलोक में सनी शंकर प्रसाद माझी द्वारा सिंदरी धनबाद जाकर उक्त शैक्षणिक प्रमाण पत्र की जांच की गई तो उसे गलत पाया गया. इसके लिए अपचारी को रांची जिलाधीश संख्या दिनांक इतना के द्वारा निलंबित किया गया तथा इस जालसाजी के लिए उनके विरुद्ध बरियातु गुंडा कांड संख्या 16 अंडर धारा 420, 467, 68, 71 भादवी अंकित किया गया जो अनुसंधान अंतर्गत है. इस विभागीय कार्रवाई का संचालन श्री हरीशचंद्र सिंह पुलिस निरीक्षक लालपुर अंचल रांची द्वारा किया गया. संचालन पदाधिकारी द्वारा विभागीय कार्रवाई के संचालन के दौरान अभियोजन साक्षियों का बयान लिया गया. अपचारी को बचाव का अवसर दिया गया. अपचारी द्वारा बचाव स्पष्टीकरण समर्पित नहीं किया गया. संचालन पदाधिकारी द्वारा विभागीय कार्रवाई का संचालन उपरांत लगाए गए आरोप के लिए अपचारी को दोषी पाया गया है. वरीय पुलिस अधीक्षक रांची द्वारा संचालन पदाधिकारी के मंतव्य के सहमत होते हुए अपचारी की सेवा से बर्खास्तगी के विरुद्ध बचाव स्पष्टीकरण का मांग किया गया. अपचारी द्वारा सेवा बर्खास्तगी के विरुद्ध अंतिम बचाव स्पष्टीकरण समर्पित किया गया है. वरीय पुलिस अधीक्षक रांची द्वारा अपचारी के बचाव स्पष्टीकरण से अवलोकन उपरांत असंतोषजनक पाकर रांची जिलाधीश संख्या इतना गठित ज्ञापन इतना द्वारा अपचारी के विरुद्ध गठित आरोप के लिए दोषी पाते हुए संविधान के अनुच्छेद 311(2)(b) के प्रावधान के अंतर्गत कार्रवाई करते हुए इन्हें सेवा से बर्खास्तगी का आदेश पारित किया गया है. अपचारी द्वारा वरीय पुलिस अधीक्षक रांची को पारित राज्यादेश के खिलाफ अपील आवेदन समर्पित किया गया है. अपील आवेदन में षड्यंत्र रचकर इनके प्रमाण पत्र को बदल कर उसके स्थान पर अन्य प्रमाण पत्र लगा देने उनके द्वारा मध्य विद्यालय चांदमारी द्वारा निर्गत प्रमाण पत्र आवेदन के साथ जमा करने जिसमें जन्म तिथि 4/3/1985 अंकित होने के मध्य विद्यालय रंगमटिया सिंदरी का प्रमाण पत्र प्रस्तुत नहीं करने विभागीय कार्रवाई संचालन का नोटिस नहीं दिए जाने आदि का उल्लेख किया गया है. मैंने अपचारी द्वारा समर्पित अपील आवेदन आरोप पारित दंडादेश संचिका में उपलब्ध अभिलेख और कंडिकावार टिप्पणी का अवलोकन किया. अपचारी विज्ञापन संख्या 1-10 के तहत पुलिस के पद पर नियुक्ति हेतु समर्पित आवेदन के साथ के मध्य विद्यालय रंगमटिया सिंदरी धनबाद द्वारा निर्गत शैक्षणिक प्रमाण पत्र संलग्न किया है जिसका सत्यापन वरीय पुलिस अधीक्षक रांची द्वारा कराई गई. सत्यापन के क्रम में प्रभारी प्रधान अध्यापिका कृष्णकांत मध्य विद्यालय रंगमटिया बलियापुर सिंदरी धनबाद द्वारा उक्त प्रमाण पत्र को कार्यालय अभिलेख के आधार पर गलत पाया गया. वरीय पुलिस अधीक्षक रांची द्वारा सहनी शंकर प्रसाद माझी को के मध्य विद्यालय सिंदरी धनबाद भेजकर उक्त शैक्षणिक प्रमाण पत्र का जांच कराई गई जो गलत पाया गया. उक्त जालसाजी के लिए अपचारी के विरुद्ध बरियातु गोंडा कांड संख्या 16 अंकित किया गया. विभागीय संचालन क्रम में अपचारी के विरुद्ध जालसाजी धोखाधड़ी कर बिना सूचना अनुमति अवकाश से फरार हो जाने एवं फर्जी प्रमाण पत्र के आधार पर पुलिस के पद पर नियुक्त हो जाने का गंभीर आरोप प्रमाणित हुआ. अपचारी द्वारा अपील आवेदन में ऐसा कोई ठोस आधार प्रमाण प्रस्तुत नहीं किया जिसके विरुद्ध लगाए गए खंडित होता है और समीक्षा पर अपचारी का अपील आवेदन स्वीकृत किया जाता है. Rita.
When is your second show course? Second show course was issued to you. बताइए भाई.
Your Lordship, that is an Annexure B, Your Lordship.
This is the next.
Annexure B.
This is this.
If Your Lordship would come to page number 34. No, that is not on record, Your Lordship. If Your Lordship would read page number 33, the dismissal order of the counter affidavit, Your Lordship, the last line, जिला धनबाद के पता पर निबंधित डाक के माध्यम से सेवा से बर्खास्ती के विरुद्ध 15 दिनों के अंदर स्पष्टीकरण समर्पित करने हेतु नोटिस भेजी गई थी। उक्त ज्ञापन के आलोक में आपके
Page
33 of the counter affidavit, last line, Your Lordship. जिला धनबाद के पता पर निबंधित डाक के माध्यम से सेवा से बर्खास्ती के विरुद्ध 15 दिनों के अंदर स्पष्टीकरण समर्पित करने हेतु नोटिस भेजी गई थी। ज्ञापन के आलोक में आपके द्वारा सेवा से बर्खास्ती के विरुद्ध स्पष्टीकरण समर्पित की गई, जो अवलोकनोपरांत असंतोषजनक पाया गया।
Where is this reply?
Your Lordship, that is not in a counter affidavit. Reply given by the petitioner is not annexed.
He has only annexed the reply which her father has sent, Your Lordship, to the department.
Can you file any rejoinder to this? Firstly, you are not annexed the order of the disciplinary authority. The order of the disciplinary authority says that same should only be, and you responded to that. That is not okay. The petitioner had participated in the disciplinary proceedings.
Your Lordship, she had replied as per the dismissal order. She has given her defense reply, Your Lordship. That is not on record, Your Lordship.
Where is it mentioned in her punishment order that she gave her defense reply?
Your Lordship, on the same line which I was reading on page number 34, उक्त ज्ञापान के आलोक में, the top line, Your Lordship, उक्त ज्ञापान के आलोक में आपके द्वारा सेवा से बगासी के विरुद्ध स्पष्टीकरण समर्पित की गई. Yes, Your Lordship.
In the disciplinary proceedings, did she participate?
Initially, she had not participated by virtue of, Your Lordship, Annexure 3 to the writ petition. Her father had replied to the Police Up Mahaniraksha. Annexure 3, page 24 of the writ petition.
This was filed when?
There is no date, Your Lordship. It has not been pleaded in the writ petition, Your Lordship. The date of the application is not mentioned, Your Lordship. It has been annexed by the petition. Moreover, Lordship, after the appellate order has been passed, the petitioner has not preferred revision, Your Lordship.
Case number 1867 of 2015, Council of the Party. The petition has been filed challenging the order dated 17/8/2013. As contained in memo number 3195 written by the DO, passed in Departmental Proceeding number 259 of 2012, whereby order challenge की है ना?
Disciplinary order has not been challenged.
The improved order is at page.
That is the next?
Annexure 4, page 25 onwards.
whereby the appeal filed by the petitioner has been submission में लिखिएगा because आपका main relief में वैसा नहीं दिखा. Whereby the appeal filed by the petitioner against order of dismissal has been rejected. The learned counsel for the petitioner has submitted that. The allegation against the petitioner was regarding obtaining employment on the basis of forged certificate. He has submitted that. After that, the petitioner had received charge sheet dated 21/8/2012. And a criminal case was also lodged against the petitioner in Bariatu, Gonda, case number 194 of 2012, registered under section 420, 467, 468 and 471 of Indian Penal Code. They have also suggested that the criminal case is still pending. The learned counsel appearing on behalf of the respondents on the other hand while opposing the prayer has submitted that a counter affidavit has been filed in the present case and the order of the disciplinary authority has been annexed. The petitioner is not aggrieved by the order of the disciplinary proceedings in the petition, nor has annexed those documents. He has submitted that. A second show cause reply was filed by the petitioner and the order of the disciplinary reflects that the petitioner the petitioner had participated in the disciplinary proceedings. Has the order of the disciplinary authority reflects that the petitioner was dismissed after conducting the required inquiries from the competent authorities and it has also come on record that the certificate filed along with her application for appointment was also sent for verification and after due verification it was found. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that admittedly the impugned order in the present case is only the appellate order. The order passed by the disciplinary authority has not been challenged in the present proceedings. The fact remains that the petitioner was appointed as police constable by advertisement number 1 of 2010. And after her appointment, her education certificates were found to be, was alleged to be fake, and she was served with a charge sheet dated 12/8/2012 as 21/8/2012 as contained in Annexure 1 to the petition, it appears that a criminal case was also instituted against the petitioner. However, a criminal case was also instituted against the petitioner. The petitioner was punished in the departmental proceedings, in which number of witnesses were examined. The departmental proceedings also indicate that the documents as produced by the respondents indicate that in the departmental proceedings the witnesses were examined and the certificate submitted by the petitioner was sent for verification, which was not found to be genuine. Thereafter, the petitioner was issued second show cause, and she responded to the same, but ultimately the petitioner was dismissed from service by order dated 14/3/2013. The petitioner filed appeal, and the appeal was also dismissed by reasonable order, which is the only order included in the present case. Considering the fact that the petitioner was subjected to disciplinary proceedings and was found guilty, and after following the procedure, she has been dismissed. No case for interference is made out in the review order in this petition, which is dismissed.
Item 16 may be posted for 2nd February.
16?
Yes, item 16.
तो नहीं पहुंचे ना हम लोग।
नेक्स्ट वीक 2 केस आ जाएगा तो इसलिए 3rd वाले को 2nd
ऐसे
February.
Subject to lordship